Joining us for today's webinar on Privacy Shield Invalidation and the impact on supplier governance. My name is Yvonne and I'll be your moderator for today. Thank you all for joining us on this beautiful, beautiful day. So I want to tell a story. Recently, I was volunteering with a global nonprofit organization with their partner. And one of my coworkers, recently emailed us all a list of names. This contained things like contacts, phone numbers, volunteers in many countries as part of a large WhatsApp group discussion. And that got me wondering, with all the focus on PII data, was that even okay for them to do? Are there regulations that need to be enforced like so? And so that brings me to the subject at hand, Privacy Shield and its recent invalidation, the impact that it has on supplier governance and compliance. We have here Punit and Nipun. Punit, let's start with the basics. What is Privacy Shield?
Hey, thanks for having me. Regarding your question, what is Privacy Shield? You probably know that in Europe, privacy is a fundamental right. So EU naturally has strong data protection rights or data protection laws as well. And in that context, you may have heard about EU General Data Protection Regulation or the GDPR. So these laws and the GDPR requires that when personal data of EU citizens travels outside of EU, the data protection standards travel along with it. That means there need to be sufficient safeguards to protect personal data. And in that context, there are few safeguards which are accepted as something as relevant and providing sufficient security when personal data is being transferred. And this Privacy Shield was one of those frameworks, one of those things which was agreed between the US Department of Commerce and the European Commission. And there were two privacy shields, one the EU-US Privacy Shield, and the second there was this US-Swiss Privacy Shield, and both have been invalidated.
Thank you so much for the clarification, Punit. That helps me understand a lot better. By the way, Punit here is a leading privacy expert who's written 3 books that are ranked as a #1 GDPR book, and he's very, very active as a speaker on Privacy Shield and privacy rights. He's worked in tandem as a global privacy manager, privacy protection offers for Fortune 500 countries, companies. We are so happy to have you here today. But moving on to my next question. I can understand, and we all understand, what privacy shields are now. What does it mean when it's invalidated?
So invalidated means it's no longer valid, and there's some history behind it. Of course, the history is a little bit long, but I'll shorten it for you. There's an Austrian lawyer and data privacy activist named Max Schrems. He's quite active, challenging the way rules are and the way data protection is being enabled. And he challenged in the court of EU about standard contractual clauses and Privacy Shield. So just like Privacy Shield, there's standard contractual clauses, which is another way of safeguarding data protection or transfer of data. And he challenged it, the legality of this system, that EU adequate level of data protection is not ensured, especially in case of Facebook. So when Facebook transfers data from EU to the US, there's not enough protection. And the Court of Justice in the EU struck down the Privacy Shield, which is the widely used mechanism for transfer to EU to US, and also ruled that standard contractual clauses, if they are used, the company is using it and the company is receiving data, need to conduct an assessment to ensure that even standard contractual clauses are offering adequate protection. And it's estimated, especially in context of Privacy Shield, that about 5,300 companies were relying on Privacy Shield, and now they need to find an alternative. safeguard alternative means to make sure those contracts are relevant. Because it's easy to say Privacy Shield is invalidated, but what happens with the contracts that were using it? And that's the big challenge now.
That is a very big challenge. Thank you for bringing that up to light. It makes me question, what does this mean for all the supplier contracts where PII is processed or accessed by suppliers? For this question, I'm actually going to turn to Nipun Sehgal, who is the CEO of Enlighta, a leading provider of solutions for supplier governance, data privacy, and contract risk and compliance management. Nipun, how are you?
Good, Yvonne. Well, thanks for the question, and glad to be on this chat with Punit and you. So, I'll take that question. So the question is, what does it mean for supplier relationships in general and supplier contracts? And I would say that it really means that companies have to have a much greater understanding of what personal data is being collected and where all it is going to in terms of suppliers or partners or affiliates. And what I would say is that there's been an explosion, an absolute explosion in the number of entities that most organizations deal with. So it used to be your tier one, tier two suppliers, but now with SaaS solutions and mobile apps and gig workers and affiliates, and so your organizations, your customer and your employee data, your personal data might be landing up in many with many organizations and in many different jurisdictions. So that's certainly something that adds complexity to figuring out what are the supply contracts that are impacted, right? And I would say that's the starting point to do an assessment of where things are. And then obviously to have strong tools and processes that then support the ability to uh, track the flow of data, of privacy data, as well as the ability to record incidents as they happen. So there's a strong role tools and processes can play in ensuring compliance to these regulations.
So in that regard, does it mean that even a mid-sized company from, let's say, Ohio, and they're making some widgets, and some of these widgets are going to be sold through a platform in Europe, which means that they would have the European prospect and client contact information, which is very sensitive. Would this regulation even apply to such companies? Punit, what do you think?
Well, the fact of the matter is, yes, it would. It doesn't matter where you're based out of, it matters whose personal data you're processing. So if the company in Ohio is processing personal data of EU individuals, it would apply. And it's not just GDPR. There has been so many privacy laws, privacy regulations in last 5 years. I think more privacy laws in last 5 years than ever before. I mean, we've had California Consumer Privacy Act, we have had Nevada privacy law, we've had the LGPD in Brazil, we are hearing out that personal data protection bill in India, and so on. So irrespective of where you are based, it doesn't matter. It matters whose personal data you are processing, and that's the key question. So this company processing or based out of Ohio would need to comply with EU and compliance and applicability of GDPR in entirety. However, we are here talking about data transfers. So even in that case, it would be considered transfer of data and they would need to comply. And for example, the Irish authorities recently asked Facebook to keep data of EU individuals in EU. Of course, that has been challenged in the court and we will see what happens. But the trend is that if you're processing personal data from a region, you need to respect laws of that region and make sure adequate level of protection is there even when data moves to another region.
I understand. So this is a really big deal. What happens if companies are not compliant? Punit?
Well, that's the biggest challenge, and that's why these laws are being talked about so much, because take, for example, EU GDPR. So if a company is non-compliant with EU GDPR, it can be fined up to 4% of global turnover or 20 million, whichever is higher. So the small company we were talking about in Ohio maybe would be fined 20 million, but a large company which is operating multiple countries and so on can have 4% of global turnover. So there are huge, huge fines, and that's why the risks are high. So it's about managing the risk and taking decisions which are risk-based and which help you mitigate the risk or reduce the risk. And it's not just about fines, it's also about reputation and operational impact, because if you are fined, you need to put a lot of effort, a lot of energy into making sure that you are communicating right with the stakeholders, shareholders, media, and your customers. And there you spend a lot of money. And then there's also a risk of some lawsuits and other things which would cause other costs for the company. So yes, it's a challenge for everyone.
I can imagine. I can definitely understand how it would be even more so a challenge for a mid-sized company when they don't fully understand what they're getting into when they deal with international data and, quite frankly, international data laws. So now what? The privacy, let's say that, we're talking about the same company in Ohio. The Privacy Shield has been invalidated. How would it affect the supplier contracts, Punit?
So it's based on what was being relied upon as the basis for transfer of personal data. So if the safeguard was Privacy Shield, now that's invalidated. That means your contract is effectively, or between quotes, no longer valid, or you need to find another way of making sure that your contract is transferring data based on a valid reason. So that's one scenario. Second is if they were using standard contractual clauses or any other means, then they need to do an assessment. And based on that assessment, they would need to identify the risks, mitigate the risks, and of course, theoretically, we can say stop processing personal data is also one option. But I would not go there. I think we can find solutions by looking at contracts, identifying the risk and mitigating the risks. And especially in case of Privacy Shield being used, we need to look at alternative mechanisms, alternative safeguards to make sure contracts remain relevant.
So are there things that companies that are dealing with European data or let's say just international data in general can do now to avoid being non-compliant in their supplier chain?
Well, ideally, yes, they can look at the contracts, but the life becomes easier if in the past years they have invested into systems and structure of contracts. So systems like third-party risk management or third-party management or contract management solutions, because if you have that, you would ideally have an insight into what contracts include personal data processing, what's the basis for that personal data processing, and where is that data flowing. So kind of a data flow. If you have all that information, then life becomes, between the quotes, easier compared to the other scenario that you would start with a list of contracts which are transferring personal data based on Privacy Shield. So you have already a head start. While if you don't have made these investments, you will need to look at kind of starting from scratch, making a list of all the contracts, identifying which ones included PII, which ones had Privacy Shield, which ones had EU-US data transfers or data flows. So then it's a little bit longer process, a little bit more complicated. But here I like to ask Nipun, based on your experience, how do you see this contract management or supplier governance? Do people always have insights into where data is flowing? Do contracts, do they always mark it? Because I know these tools are fancy, they provide all these features, but do people keep that record?
Yeah, actually, it's a great question, Puneet. So I would say, while larger companies have invested in third-party risk management and contract lifecycle management, it's definitely, we see that there's a lot of interest in that, and especially with COVID, I think companies have certainly realized that their supplier relationships are much more important than they thought they were, because your entire supply chains have been disrupted. But a lot of mid-sized companies still haven't made that investment, right? And it could be that they hesitate based, they think it's very expensive. It's a very, it disrupts their normal day-to-day operations to go through this exercise. But as we are discussing, it is absolutely required. And not being compliant has got tremendous implications on reputation and possible fines. So we are a tools company, and we looked at this, and we've invested in building out a very easy to use, low cost offering called Enlighta Spice, mainly for those mid-sized organizations where there is a need. They do deal with European data or international data, or California data, for example. And it really combines all of the things that clients are looking for, which is a repository of your suppliers and your affiliates. So really understanding who are the entities that you're dealing with to start with, and then second, having a repository of all your contracts. But then, who's got the time to go through all these contracts and figure out, do you have personal data privacy clauses in there? Are they standard clauses? So, we thought that investing in machine learning, artificial intelligence would allow these companies to rapidly get a assessment of where they stand with respect to data privacy clauses in their contracts, right? Which contracts have those, which don't, and if they are they standard across all these contracts? So that's really the first part of it, simply getting an understanding of who the entities are that you should be concerned about, what are the contracts you should be concerned about, what are the clauses that should be standard. And then on the other side, on the operational side, very often these laws also have obligations for customers for enterprises to be able to respond to incidents, or at least notify. So if there is a breach of some kind and personal data was impacted, then the impacted individuals need to know about that. And each of these laws indicates what time frame the enterprise has to notify the individual that their data might have been impacted. So unless you know very clearly which are the suppliers that you had shared that information with, you may be able to say that, yes, we know we have addressed this, we have this breach and we've taken steps, but you may not know what are the implications downstream in your supplier and third party systems. So having that data flow that you mentioned earlier, Puneet, having the ability to track incidents as they happen, to automatically notify through systems, all of that plays a huge role in having mid-sized companies very quickly get compliant to these privacy laws.
Nipun, you've given us a very multifaceted and comprehensive approach to the data compliance issue that we have here. But I would like to know, though, if you were a company, what would be the first thing that you'd do in order to tackle your own data compliance problem?
Well, I would say that having as what Puneet was mentioning, having an understanding of who are your, not just your immediate suppliers, but their subcontractors and your affiliates and other entities that may have access to your employee data or your customer data, so personal data, and then understanding where things stand with respect to your agreements with these entities. I think that's really a good starting point. An assessment is a good starting point of that. And I would say that experts like Puneet play a huge role, right? I mean, instead of an enterprise figuring out all of this by themselves, you could certainly reach out to experts like Puneet, who can come in and very rapidly provide templates.
Well, yes, a couple of things. I think what you highlight through Enlighta Spice is there's a saying like you cannot manage something which you don't know. So if you are not using supplier governance or third-party risk management tools like Enlighta, then you don't know what contracts you have, and you don't know if personal data is being processed outside of EU or in EU-US data flows. So it's important to invest into your risk management systems even now, because okay, you will need to tackle this challenge on the privacy shield in a different way, but in the long term, the standard contractual clauses would also get refreshed. And who knows what are the conditions, and you may need to rewrite the contracts using standard contractual clauses. So it's still a good time to invest into third-party risk management. And specifically in context of the privacy shield impact, I think I would do three specific things. Identify the contracts that involve personal data processing or personal data transfers in across EU, EU-US, or EU other countries. And for the ones that are based on Privacy Shield, work with your legal and privacy teams to rewrite those contracts or amend those contracts. And for all others, which maybe are based on standard contractual clauses or binding corporate rules or whatever, assess the risk, and based on the risk, make your decisions. Mitigation of risk, limitation of risk, or acceptance of risk, whatever is needed. So do those three things and start to look at your privacy management, your supplier management as one thing, because when data travels even outside your company, it may be processed by some other party, but you're still accountable, you're still responsible. And that's where these investments pay you off in the long term.
That was a very comprehensive plan. So Punit and Nipun, thank you so much for this informative and helpful session. I, for one, learned so much about data compliance and how audience here today has the same feelings as well. If you wish to reach Punit Bhatia, Nipun, if you can show our title slide. Both Punit and Nipun's contact information can be found on the screen. I recommend that you screenshot it real quick. Actually, Nipun and Punit, do we have time to take questions from the audience?
Yes, absolutely.
Absolutely. All right, then let me just check the chat really quick to see if we have anyone typing up any questions here. Understandably, data compliance and regulations can be a tricky topic to maneuver. Oh, here we go. Can AI help companies get compliant with privacy regulations? What do you guys think about AI's role in data compliance and security?
Well, it's a great question, and I would say that for those enterprises that have not made that investment that Puneet and I were talking about in terms of understanding their contracts, it turns out, if you've got hundreds of contracts, machine learning and AI can play a big role, because now you can actually automatically determine whether do you have privacy clauses in those contracts, and if you do, are there standard clauses or not? And then as things change over time, as there are more regulations, you can actually determine whether all the right jurisdictions, all the right regulations are in those privacy clauses. Like, for example, if you've not got the California Consumer Protection Act included, then certainly you would know that. AI can help you know that, and then you can have standard clauses that can be added as amendments. So I think AI can certainly play a role. AI can also figure out the flow of data. So you may not be aware of all the interfaces and how your data is flowing. And certainly with the right investment, AI can help there too. Puneet, anything to add?
I think you said it pretty much all. So AI can certainly make life easier and simpler, but always be aware that while AI would assist you in privacy compliance, AI would not make you privacy compliant. So you need to do things around it, but those things around it, they are made easier. Your job is made quite simpler, and you get access to information which otherwise you will take weeks or months to get to.
Okay.
Which is a core part of this discussion, automation really does play a huge role in helping you stay data compliant.
Puneet is in Europe. It's rather late for him. So, um, well, thanks, Yvonne, for moderating, and thanks, Puneet, for participating in this. Really appreciate that. And you can reach us at the email addresses below. Thank you.